So good afternoon, everyone, and welcome to today's webinar. I'm Callie Waterhouse with Arizona Realtors, and we are thrilled to have you join us today for criminals, credit, and the new HUD guidelines. We have entertained quite a few questions recently about the new HUD guidelines, and I have told everyone to please join us for today's webinar with Mike Mumford. If you have attended Mike's webinars in the past, you know that he is our go-to guy for regulations, accounting, compliance, and a lot of property management stuff. Mike's been involved in property management since 1996 when he joined Bennett Property Management. He has managed, goodness, upwards of 250 units at a time, and he is now the office manager and chief financial officer for Bennett Property Management. But in addition to that, he is also one of 6 RVPs for NARPM. He is our Southwest Regional RVP, which means he kind of represents and helps out 5 states and 12 chapters and a ton of property managers. So with all of that being said, welcome back, Mike.
Thanks.
You're welcome.
Appreciate it. And I'm glad to hear we have a few long-term property managers on the call as well. This is my 20th year this month, so those of us that have stuck it out for a while, it's always fun, always interesting. The new changes have been a little interesting this year, shall we say, and there are more coming. And we're going to talk about those today. Callie mentioned NARPM. Those of you on the call, if you're not members of NARPM, most of my knowledge and this information I've gotten through the NARPM group. It's very active in the single-family home property management industry. We have about 300 members in the state. We have 4 chapters in the state of Arizona. We have one down in Tucson, one in Prescott, and 2 here in the Valley, east side and west side. I would highly recommend it. It's a great organization that specializes in single-family home fee management. And one of their key goals is education. I recently taught this class at the NARPM convention in Maui last week. So that class went a little long and had a ton of questions. So I expect that we'll get some of the same here, and I'm happy to try to answer those as best I can. One of the issues with this new guidance that's coming out is there's not a lot of clarity yet. We're going to have to wait till some court cases come through and some decisions are made by either the courts or the attorneys or somebody above our pay grade until we know what to do. But my goal in teaching this class and talking to you today is to make sure that you guys aren't the target out there. If you don't know, HUD has issued over $38 million to over 100 different either entities or people to come test property managers across the country. And we've already had several of those cases come through. So the goal right now is to keep your head down and keep the target off your back and make sure you're not the test case. The test case, whoever gets sued and has to go to the Supreme Court and go up through, is going to be very, very expensive. So until all of this plays out and we get better instruction from our attorneys and from the courts, the goal is to not be the target and to make sure that you pass any of the testing that comes through. So let's go ahead and get started here. I want to talk a little bit, especially to you old timers that are doing it, about how we used to do things in the good old days. So it used to be when you met a person, most of your clients, we didn't have the internet back then. We had newspaper ads and signs in the yard, and most of them were referrals. Another broker would come or a tenant would come. Somebody would bring a neighbor, a friend, someone from church, somewhere else. But you would get referrals, and it would be somebody that you knew from a friend of a friend or knew from an associate. And we didn't really stringently screen them as much as we can now. That just wasn't available. The background screening that was available, the other stuff that was available now wasn't available back then. So if they had cash in hand, if they wore nice clothes, if they drove a nice car, these were the things that kind of stuck in the back of our head. We didn't really screen off of that, but you got a general feeling from the tenant. Those of you that have lower end properties, if they get fog of mirror, they were in, right? So, and now, today, we look at what we've got here. We have the 7 protected classes, and we've had these for a long time. And these have been around since the 60s. You have disability, familial status, sex, national origin, color, religion, and race. Those are our guidelines of what we've gone through. And we still cannot discriminate against those. And the new stuff that's come up, the new guidelines that have come up, especially in disparate impact and some of the other things, are not new concepts. They're just now being applied to property management. So these big 7 is what we had to deal with. That was really what we worried about. We worried primarily about block busting and steering. Those were the big ones before. That's what people got in trouble for. Even up to 5-10 years ago, those were still big issues. In property management and sales and lending, those were the top issues. Those are not the top issues anymore. The new issues that are coming up, the number one issue for HUD for complaints is against disabilities now. So disabled persons, the complaints and the lawsuits have come more from them than from any other of these protected classes or any of these other issues. So fast forward to today, all of you are probably using a professional screening company, and we've gone from being able to do our own criminal background checks and going and checking our own stuff to checking so many other sites. Nowadays, when you use a professional screening company, we've gotten way better at finding any issue in a tenant's past or an applicant's past. Used to be a lot of those didn't come over, they didn't port over, not all of the counties had their records online. Unless you had a private investigator actually go into the county of where that person used to live, there was a good chance you weren't going to get any of the criminal background or any of the eviction records or a lot of these other things. Now we have nationwide companies doing screening, and the amount of stuff that they screen is just crazy. So I pulled ours up, and this is just a sample of the things that they check. I couldn't fit them all on the screen. It was crazy. I had no idea. I know they said they do a good job and they're good, but when I pulled it up, all of the different things that they check, it is unbelievable. Medicare fraud search. I did not know that there was a Medicare fraud database out there and that they were screening my applicants against that. I had no idea until I did the research for this class. The amount of information that they're getting and the amount of registries and the checking that they're doing now has caused us to get much, much better at our job in screening these applicants. And I think part of what we're dealing with now is a little bit of pushback to that. So because we've gotten better at our job and better at doing this, we need to pay attention and make sure that we're doing it in a useful and a compliant way when we're using these background checks. So, excuse me. So HUD Guidance, this is where it all started, and this is where all the ruckus started. They put out a guidance in April of 2016 that said the court idea of disparate impact applies to property management. And really what that means, if you look at disparate impact, the idea behind that is unintentional discrimination, where you have a policy or a system in place and you're discriminating, but not overtly discriminating, not necessarily trying to discriminate, but because of your policy and how it's written, you end up discriminating without meaning to. So this is an issue today, and the big one that came out from HUD was criminal background. And what they have said is if you deny everybody with a criminal background, you are having a disparate impact against minorities because more minorities are convicted of crimes than not. So by having a policy of no felons or no criminals, you are inadvertently discriminating, and that's the problem. So that's what they're doing now. And when you think about it, some people have policies, no criminals, no felons, and let's think about that for a second. Let's think about the call to Mr. Owner and saying, hey, I've got this great couple. They want to rent your house. They make 4 times the rent amount as income, great steady jobs, wonderful rental history, no kids, no pets. They're perfect for it, but we're going to have to deny them because they have parking tickets, and we don't want that criminal scum in your property. So because of parking tickets, we're not, well, parking illegally is a crime. So when you say no criminals, what do you really mean? Are you not going to rent to somebody with a traffic ticket? Traffic tickets can be felonies. So if you have a policy of no felonies, are you going to rent to somebody who went over 20 miles an hour over the speed limit and got a felony traffic violation? You probably would. You probably would rent to somebody with parking tickets. So we already kind of think about that. When we have a policy of no criminals or no felons, we mean only certain things. We don't really mean traffic tickets. We don't mean some of the other things. And so we really need to take a step back, and that's really what this guidance tells us to do. It tells us to go back and reevaluate our policy and say, okay, why are we concerned with any criminal background at all? What's the concern? What are we really trying to accomplish? And what we're trying to do is we're trying to protect the property, the owner's investment, the house, and we're trying to protect the quiet enjoyment of the neighbors. We don't want to move somebody in who is going to be a potential threat to a neighbor and cause issue with the owner. So for instance, an arson is probably somebody you don't want to rent to. That's protecting the property. Somebody who's a sex offender that you move into a multifamily unit, that may be a potential threat to anybody who has families in the unit. Those are very true and very easy ones to look at, but a lot of the other ones are not. So having a criminal background or a policy of renting to no criminals and no felons is going to cause an issue. HUD has come out and that's exactly what they're testing for. So what do we need to do? Do we need to change our policies? Do we have to change that? HUD has said you are allowed to run criminal background checks. You are allowed to ask, have you ever been convicted? Do you have a charge pending? That's okay. But you have to have reasonable guidelines and have rules and policies in place that are specific to protecting the property and protecting the neighborhood. So let's talk about that again for felons. There's so many different reasons out there, different types of felonies. We talk about the arsonist or the person that's been convicted of rape and murder. That's a felony. But let's talk about the 18-year-old kid that came back from Mexico with a couple of Cuban cigars for his dad. That's also a felony. Are we going to not rent to the 18-year-old now that he's 30 years old and has a good job? He was convicted of a felony, but it was a long time ago, and it's not going to affect his ability to pay or his ability to take care of the property. So we need to have guidelines and guidance in place, and that's what this HUD ruling comes back on. So that's what they're talking about. And in order for us to keep our head underneath the radar, we need to look at the recent cases out there. So if you don't know, there have already been several cases come through. I'm going to talk about a couple of them. The first one is in Washington. In Washington, they sent a tester out. An ad in Craigslist said no felons. They sent a tester out. Said it was a felony a long time ago. They didn't ask any questions. The property management company just flat out denied them and said, we don't accept felons. No questions. No questions as to how long ago it was, what type of felony it was, any other information. No felons allowed. So they got sued by the Attorney General's office of the state of Washington. They've been ordered to pay $15,000 on a consent decree, and they're fighting it. But the state of Washington's Attorney General has come out and said, not renting to criminals is discriminatory, period. Now, they've gone a little aggressive on that, and if you know the different states, every state's a little bit different. Washington tends to be a little more liberal. Washington has some other guidance in for cities and counties that we don't have, like source of income as a protected class there. It is not here and not in a lot of other states. They have other LGBT communities that are there that you cannot discriminate against that, which is not a federal law. So they tend to be a little more liberal on that, and that's just something that's come up recently. It came up 1 month after the HUD guidance came out is when this started, and it's come to fruition now, and the property management company looks like they're going to have to write a check for $15,000. If not, they're going to have to fight it, and the legal fees are going to be huge on that. So in Texas, a case came against a housing authority. Now, this was not on criminal background, but it came against a housing authority about how they allocate funds for their tenants there. And in the case in Texas, it moved forward through a couple of stages, but in the final stage, the state of Texas dismissed the case, saying that the people who brought the suit could not prove that there was actual harm, that there was actual discrimination against this. But it got through the first couple of steps on that. So definitely something to be concerned about, something to think about. and to pay attention to. Again, remember, $38 million out there for testers coming through. And this is something this is making the news all over. There was a report in the U.S. World News and Report that came out in October regarding this issue. It's making national headlines in the papers and all over. So the thing to be concerned about with there is, with it being that out there and in the public view right now, it's being talked about quite a bit. Your tenants know about this. Your applicants know about this stuff. So we really need to be prepared, because applicants have free lawyers. If they contact HUD and Fair Housing, the case starts, whether they have any money or not. They can file a complaint against you. And if you've never gone through a complaint from HUD or Fair Housing, let me tell you, it is not fun. We went through one against us, and it was a horrible experience. We did nothing wrong. We were found to have done nothing wrong. We were completely cleared, but it took 5 months and several $1,000s in legal fees. It's not fun, guys. So again, the goal right now is to make sure you change your policies, change your advertising, change how you're talking about this, to make sure that you don't have the target on your back, that you're underneath the radar for this stuff. Now, I'm going to go over a few things on do's and don'ts. NAR actually came out with this list. I know it's really hard to read on there, and I'm not going to go over this line by line. I just wanted to put it out there. This is something that came out from NAR immediately after the HUD guidance came out in April. It's got some really good stuff on there. And again, this is going to be review for a lot of you, but I think it's a really good idea to make sure that anybody doing your screenings, anybody doing your showings, looks at this list, takes a look at these items to make sure that you are thinking along the right lines, that you're not violating this stuff inadvertently. Some of the things on there, consider the amount of time that's gone by. Consider the nature of the problem. So again, you need to revise your policies. You need to take a look at this. This is something you got to do right now. So look at your applications, look at your policies, and make sure you do that. So take a look at that when you have a chance. I'd get it out there. So from the HUD guidance, this is cut and paste directly from HUD. It does not stop you from running criminal background checks. It does not stop you from asking those questions. What it tells you to do is have thoughtful policies and practices that have a legitimate interest of the housing provider, resident safety and protection of the property. Those are the two things that you want to make sure you're taking into account when you set these policies up. So take a look at that. Now, I talked to a couple of attorneys, and I looked, and I've got some policy suggestions for changing your policies. And the next couple of slides, we'll go over those. I don't want to read those over because I know you guys are probably going to have a lot of questions. But having a time frame for convictions is probably a really good idea. Whether that's 5, 10, 7, whatever you're comfortable with is fine. And having a list or an idea that says primarily concerned with person and property crimes is a good idea. If you want to have a list like they do here that says including but not limited to, that's okay. If you want to just say person and property crimes, that's okay. But you need to have a policy and you need to treat everybody the same. So drug-related offenses and sexual offenses are the two things that are excluded in the HUD guidance. They understand that renting to a sex offender, regardless of how old it is, can be a harm to the property. Some sex offenders are required to be registered and required to have a notices given out to the neighborhood regardless of how long ago that was. So you could have a sex offender that was convicted 15 years ago that may still have to have the nice little flyers that says, Bob just moved into your neighborhood, tell your kids to watch out for Bob. And that could be a huge deal for your owner, for the value of the property, for other things. So sex offenses are excluded specifically, so you do not have to rent the sex offenders. Now, drug convictions are a little different. On the drug guidelines, what they've said is possession is not specifically excluded. If you have someone who's been convicted of a possession crime, that's something you need to take a look at. If you have someone who's been convicted of manufacturing, distributing, someone who set up a meth lab in a house, those are excluded. You can stop that altogether. So But for the other drug offenses, you need to be concerned. If it's possession only or alcohol-related offenses, if nobody was injured or killed, the guideline here says that that's more than 2 years old, you should probably rent to that person. I'm not telling you what kind of policy you need to set up. I'm telling you what the guidelines say and what the attorneys have said. So you need to just make sure that you look at your policy, that you've taken a look at these things, and you set up a new policy and guidelines and train your staff on it. Make sure that everybody knows. So also, you need to be aware, when you run a criminal background check, there are lots of states that will not give you anything older than a certain age. So anything older than 7 years old, if the person is coming from one of the excluded states, Arizona is not one of the excluded states. But if somebody's moving here from California or Colorado or Nevada, that we get a lot of people that move 1 or 2 states over, when you run a criminal background check, if the conviction was more than 7 years old, it's not going to show up on your screening. They're not allowed to give you that information. So you need to be aware, even if you ask the question, have you ever been convicted of a felony? Those of us that have been doing this for a long time have seen where they answer, yes, I have, and they write down what it was, and you run the criminal background check and it says no, nothing found. Well, that's why. The background screening company is not allowed to report those things to you. So even if you want to continue with a policy that says, I'm not going to rent to felons, I don't care what they say, my owners say we're not going to do this, I'm going to stand my ground and do that, you're not going to find out anyway. And believe me, the applicants are going to learn these things aren't being reported. They're going to go to the first one and says, you answered yes, but I got no information back. When they go to the second person, they're going to answer no, because they know it's not coming through. So you just need to be really, really aware of that. And that's the new guidance. That's the HUD guidance on disparate impact and criminal background. Now, what's coming up on that? What's coming up next? I mean, this is really Pandora's box for this. We just had a case. I just read a case. HUD put out some guidance regarding people who speak limited English language. So for those that are of foreign descent or those that don't speak English as a primary language, they put out some guidance that said if you are not renting to those people and don't have a way to deal with that, you might be discriminating through disparate impact, because the vast majority of English as a second language speakers have a different national origin. So we need to be aware of this. Now that the box is open, the Supreme Court said disparate impact applies to real estate. Who knows what all that's going to come through? These are the things that I thought of when I came through, filling out applications, viewing properties. So if you only take applications online, are you eliminating those people without computers and maybe a different class of citizen? For viewing properties, if you only do viewings through a lockbox that requires a credit card, some of the new lockboxes that come through, are you eliminating showing to anybody who doesn't have access to a credit card or banking information? What about paying rent? Do you only take rent online? Do you only take checks? What about people who don't have checking accounts? What about submitting work orders? Do you only allow submitting work orders online? You need to think about these things, because we have come up with some of these policies, and through these policies, we may be inadvertently discriminating against an entire class of people, some protected class out there when we think about it. And that's not to say that you can't do these things. What I'm telling you is to be cautious and to make sure you've thought of alternatives. So for filling out applications and submitting work orders, we prefer that people pay rent online and fill out their work orders online. So for those people who don't have access to the internet, we set up a kiosk in our office that's free to all of our residents. So now somebody can't say, well, I don't have access to that. Yes, you do. We give you access to that. So you need to think about that when you're doing this. Methods of paying rent, checking only. If you don't accept cash, that's fine. It's legal to have a policy of no cash. But if somebody shows up 5 minutes before closing time with a U-Haul full of all their stuff and their kids and their dogs, and they have cash in hand, are you going to turn them away knowing that by the time they get back with a money order, they're not going to be able to get the keys tonight and they're going to have to pay a hotel? So you need to think about not only your policies, but think about your exceptions. Think about when that makes sense, and think about how you're treating all of your residents and all of your applicants, because I'm telling you, new things are going to be coming through on this disparate impact, and it's going to affect us all in how we do it. And if we don't adjust and get behind the times, you guys taking this class today is awesome just to get you thinking about it. Make sure you talk to your landlord attorney. I don't know who you use, but you need to talk to your attorney about this stuff, because when it starts to go south, they're the ones that are going to be in court with you. And you would hate to hand them your application in court and have them go, whoa, that's bad. Yeah, sorry you asked that one, you're going to lose. So make sure that they've vetted your contracts and vetted your policies and talk to them about it. Attend these types of events. Go to NARPM, get as much education as you can, because times there are changing. It's scary stuff. So,
Mike, how do you define disparate impact? We have quite a few new people on the webinar, and the question is, in layman's terms, what's the easiest way to explain disparate impact?
So the easiest way to explain it is a policy that makes it difficult on a certain percentage of your people. So if your residents, if you have a policy of only paying rent online can be difficult for a big chunk of your residents, depending on who you rent to, what type of properties you have, whether you have high-end properties, low-end properties. So if you have a lot of low-end properties where people can't afford internet access and you force them to do a whole lot of stuff online, you may have a disparate impact there, because of the lower income properties, a larger percentage of those can be a protected class, perhaps minorities, perhaps of a different ethnic background. If you rent in an area that is primarily one class of citizen or one group of citizen or one ethnic group, and you apply these standards and it makes it difficult on them, it can be disparate impact. And disparate impact is really difficult. So what has to happen for this to be proven against you is somebody brings up and says, I believe that I was discriminated against. HUD and Fair Housing will come in and say, okay, you have some knowledge there, then you have to prove that you didn't do it. And if you can't prove that you didn't do it, then you're guilty. If you set it up and you prove and say, hey, our policy is this, we have these exceptions, we have ways around this is how we do it, you're going to be okay. But if that doesn't fly, they're going to come back and say, okay, was there harm done? If there was harm done, then you're going to get fined. So it's really a very difficult legal concept to come up with. I'm not surprised people are struggling with it. I would recommend you go research it. I'm not an attorney. I don't even play one on TV. But I talk to my attorneys all the time. If you get a chance, there are a few attorneys around the state who teach classes on this. Denise Holliday is one of my favorites. She teaches fair housing and these issues. Look up a class from her and take one. We've only got an hour today, so I can't go into it in too depth, but I hope that helps a little bit for what you guys are looking at. So,
thank you.
Yep. Okay. So let's talk about a couple of other things here too. Adverse action. So I want to talk about this because when I talk to property managers and we talk about issues with applicants, I get a lot of pushback on this from a lot of people who do not understand adverse action. When you deny a tenant, you send them an adverse action letter saying, we've denied you based on your credit or criminal, based on your screening report that came back. I hope you all are doing that. Usually your screening companies provide that and they have that available, and you push a button and it fills it out and you send that to them. Federal law requires that you send that to every tenant that you deny. But it also requires for you to send it to every tenant that you ask to have a cosigner. It also requires that you send that to every tenant where you raised the security deposit or had additional rent collected. Anything that you do where you have an impact on a tenant, where you require some monetary or higher thing for another tenant, you need to make sure that you are giving out this letter. Now, the other attachment that I sent out today, and I'm not going to pull it up on the screen, it's several pages long. It's from the government about adverse action. But I hear all the time people go, wait a second, I rented to them. I don't need to supply this letter. Yes, you do. It's federal law. You have to do it. Guys, make sure that you're following that. So co-signers, additional security deposit, even if you rent to them, you have to give them the adverse action letter. And in my classes, I see a lot of people frantically writing when I bring this up. So that's why I leave it in there and just want to make sure that that note is in there so you guys understand that it is important, and for you to be in compliance, you have to give that notice out to them. Identity protection. Hopefully you all have a red flags policy. A red flags rule is part of also the FTC. And what it does is it mandates that anybody who has sensitive information for another individual, which we have, guys, think about all the information you have for owners and tenants and vendors and your employees. For your tenants, you know more about them than their mother does in some cases. You have their date of birth, social security number, their address, their place of work, their telephone numbers. You have a whole lot of information about those people. And so for your owners and your vendors, you have W-9s. You have a lot of sensitive information. You're required by federal law to protect that information. And that's what red flags comes down to. And if you don't have a red flags policy, please, please, please go get one. Typically, a typical red flags policy requires 3 different sets of locks between the outside and sensitive information. So if it's digital, that would require a lock on the front door, maybe a security alarm, a password to get into the computer, and then a password to get into the program. You see where I'm going with this? If it's a physical copy of an application, and the person has to go through the lock at the front door, and then they have to go through the security alarm, and then it's in a locked file cabinet, that's kind of what they're talking about. But we've all seen in recent days where Target and Banner Health and even Disney World has sent out information that says we've been compromised and we were hacked, and if you think you're a victim of this, why do you think they say that? Why do you think they put that out there on the news? Because they have to. They're required to. If there's a breach, they have to notify everybody. So if you have a breach in your office, imagine sending a letter to every single one of your owners saying, hey, I'm so sorry, but you may be a victim of identity theft because our office was breached. Wow, that could be a business ender. Same with tenants and vendors and employees. So just make sure you safeguard that information. Make sure you have a policy in place. It's federal law, you guys. You have to do it. And that's a fairly new one that's come out. It's been out for several years, but a lot of property managers haven't figured that out and didn't know that they had to comply. I talked to a lot of people who've been doing it 15, 20 years, and it came on board after they set up their policies and procedures and they didn't adapt. So guys, you got to adapt or die. It's important. So we talked about this, disabled applicants. You have to have policies in place to treat all applicants fairly. One of the quotes that I heard from an attorney when I was taking a class is, you have to treat everybody the same, but you have to treat people with disabilities better. And it just made sense to me. It kind of rung true with me, and I thought about it. There's a case in Texas that came up from a disability case. Their policy in this particular property management company is no co-signers. And so they met an applicant, a prospect at the property, said, love the property, I need 2 applications. They said, well, it's only you. And she said, I have a co-signer. And they said, we don't take co-signers. She said, I'm disabled. And they said, we don't take co-signers. And there's the lawsuit right there. That one word, we don't take co-signers. Not, oh, you're disabled. So you're asking for a reasonable accommodation of a co-signer, which is what they were asking for. But the property manager didn't say that, didn't ask those questions. Again, you've been convicted of a felony, we won't rent to you. You have to have the conversation. And so this is not resolved yet. I know they've been in process of the court case for about 6 months now, and it hasn't finalized. And they spent a lot in attorney fees fighting this. And all because an agent out in the field said, we don't take co-signers, after the person said they were disabled. So applicants with disabilities, you need to make sure that you are asking them about that, asking them about reasonable accommodations and what they are. Usually we think about in the past, and what I've always thought about for reasonable accommodations is grab bars or ramps or lowering the light switch or doing some physical thing. But there are lots of other reasonable accommodations out there. One can be when they get their rent, when their rent is due. So if you have somebody who gets assistance, their assistance check on the 7th of every month, and they say, I'd like to ask for an accommodation where I can pay by the 8th of the month without any late fees, that may be a reasonable accommodation. Now, if they don't get paid till the 25th, that may not. You need to look at, is there any harm to your owner, and is there any monetary issue with your owner? If you send your owner's money on the 15th and their accommodation is asking to be paid before the 15th, and you'd still be able to pay your owner on time with all of the other owner payments, there's not really an issue to the owner there. That may be an actual reasonable accommodation. If you send your owner's money on the 15th and they're asking to have it paid on the 22nd of every month, you can show that there's harm to the owner on that and maybe ask them to get 1 month ahead or work something out, come up with some type of plan. But those are also reasonable accommodations. Reasonable accommodations aren't always physical things. So guys, when you're talking to disabled tenants, disabled applicants, start what's called the interactive conversation. Ask them what they need, ask them what their accommodation is. You cannot ask about the disability itself, but you can ask what accommodations they need. You talk about assistive animals all the time. We'll go over that here in a little bit, but there can be all different types of reasonable accommodations, guys. So make sure that you guys have that covered. Assistive animals. Now, this is always a touchy one. Those that are disabled and need assistive animals usually know what the rules are and know exactly what to do, and they're coming through and they follow the rules. They know right what it is. They're bringing you the doctor form. They're doing that. The issue becomes when you have some people trying to get around paying a pet fee or around paying pet rent that say, I have 7 assistive animals or 7 assistive cats, or I have therapy cats, or I have a service monkey or a service pig. Crazy, crazy stuff out there. You just need to err on the side of caution on that, since it is the #1 complaint that's coming through now. You want to make sure that you are doing that. There are forms available out there that are reasonable accommodation requests and assistive animal requests that need to be signed off by a medical health provider. It does not have to be a doctor, guys. The law says a healthcare provider. Could be a nurse, could be a psychiatrist, could be any type of therapist. We really don't have clear guidance as to what that is. So I would suggest talk to your attorneys again, look for some guidance on that, and make sure that you keep the conversation open. Because it is one of the #1 complaints that they have out there. So very important to pay attention to that. So, and what's next coming up? We just talked about English learner, people that speak English as a limited source. That one's coming up. There's been some guidance issued on that. Source of income is a big one. This is coming through several of the states. California, Utah, Texas passed it in a couple of cities, and then the state shot it down. But source of income is a big one, and they're coming through and trying to say that source of income is going to be a protected class, which would mean you have to take Section 8. You cannot discriminate based on the source of income. Now, that's not to say that you can't run an application on somebody that's in the program. But you would not be able to discriminate against them based on the fact that they don't make enough income personally to do the 3 times the rent amount or 4 times the rent amount qualification. What they would have to qualify is for their portion. So if the rent's $1,000 and their portion is $100 and your qualification is 3 times the rent amount, they would have to have $300 in income, not $3,000 in income, in order to qualify to rent. And this is passed, and just so you guys know, the reason it's important in other states is once that stuff gains traction, it starts coming across to other states, and other states look at it. If it gets enough traction, then it's going to become federal law. Look at the marijuana issue that's going on. Medical marijuana was passed in several different states. Now recreational marijuana has passed in a few states, and whether you agree with it or don't agree with it, that's not what I'm talking about. What I'm talking about is once it gets enough traction and gets to over a third of the states or over half the states, federal law will probably change. That's happened on a lot of these legal issues in the past, where it starts in a few states and it gains momentum, and if it doesn't go anywhere, that's okay. But if it continues to grow, then it becomes a federal issue. And if you guys are like us, I don't have a problem with the tenants in Section 8 and helping people get housing. That's what we do. We provide housing to people. It's a great business to be in and job to be in, and we don't have a problem with that. The regulations from the federal side and from the income side are what kills us. When you tell your owner, I have a resident who wants to rent here, but we're not going to get any assistance money for 3 months, that's harmful to the owner and very difficult for them to deal with. Some of the other rules that they put on us are very difficult. So we need to make sure that we are vocal about that and let people know our opinions, that it's not about, oh, Section 8's lower class people, we don't want to rent to them. That's not it. That's not why we do that and have issue with a lot of those programs. So make sure you're clear in what you want to do. So source of income is new. Coming across LGBT. We have some cities in our state here. Tempe, I think Phoenix has some issues with that. So there are some cities. I know there are other counties in the country that have laws that require that set this as a protected class, that you cannot discriminate against any gender issues. So that's something that's out there and something you need to think about. Something maybe to think about now because it might be coming our direction. So these are just things that are coming across in other parts. Proof of citizenship. It's another issue here, primarily in Arizona. Arizona is one of the top states in the nation for identity theft. And the top reason for identity, or the top way people perpetrate identity theft, is through rental properties. In case you don't know, when somebody uses their name with somebody else's social security number, the first time you run that through credit, it says not a match. The second time you run it through credit, it says not a match. The third time you run it through the credit agencies, it becomes an alias. So think about that. If you have somebody who's trying to do identity theft and they have a social security number that's valid, they're paying the application fee to you, never intending to rent from you. They're just doing it because it's a cheap way for them to get their name as an alias on somebody else's social security number. So it's a big deal. It's huge here in this state. So if somebody gives you a social security number, what are you doing to make sure that it is them, that they are who they say they are? Are you checking IDs? There are some states that, Arizona, until very, very recently, you had to prove citizenship to get a driver's license. Well, that's changing. In other states, that's already changed and been done. So in the state of Washington, again, we've talked about Washington before, and I'm not trying to pick on them. I just happen to know several property managers up there. You don't have to provide proof of citizenship to get a driver's license up there. So if somebody comes down here with a Washington state driver's license, that doesn't prove that they're even here legally. There's something to think about. And check with your credit screening company on these things and what you're doing and how you need to revise your policies to do this. So what does this mean? It means after 20 years, we just have to juggle, guys. We have to adjust. We have to make sure we're compliant with all the new laws that are coming out. We have to make sure that we're staying ahead of it and staying on top of things. Trust me, you don't want to be the target case. There are several different issues in the state where the Attorney General is just looking for the target case, and you don't want to be that because depending on what it is, it can be a business ender. Look at the case in Washington, $15,000. If you're a small company, a mom and pop that rents maybe 50 units or whatever, that could be a huge deal, a huge deal. So be cognizant of that. You need to make sure that you're paying attention and you're staying on top of things. That's one of the reasons I love property management and been in it 20 years. It's something new every day. Something different changes, something new happens. I get a news story from a resident saying, wow, you didn't pay your rent because Easter came unexpectedly? My all-time favorite. Really? Easter? Okay. What kind of baskets are you giving to the kids? So it's always something new and always something different, but it's very important that you guys, I want to make sure that you guys are doing it right and you're compliant with the laws and you stay on top of that. So we can't stick to our old policies. We can't stick to our old ways. You can't put your head in the sand. It's just not going to work. You need to make sure that you stay on top of it. Make sure that you guys are paying attention and adjusting your policies. Otherwise, you're gonna be getting in big trouble and not going very well. So That's about it. I'm sure there are some questions in there, so let's start with those.
Well, Mike, you are correct. We have quite a few questions. And the number one question that I would think a good 30% of today's attendees are asking is, it's twofold. How do you choose a company to do background checks, and who do you use and or recommend?
We use Investigative Screening. It's a local company. I would highly recommend them. I choose them because they're local. They're here in the Phoenix area. They do a great job. There are tons of other companies out there that I would also recommend. NTN is a really good one. They're nationwide. There are a few other nationwide companies that do that. I would recommend, if you're looking for a screening company, the thing that you want to make sure you check is to make sure that they're not using old data, that they're actually checking current records. And what I mean by that is the counties put out data on DVDs or CDs or send out information every 30 days. And if you have a company that's checking the old data that's 30 days old, they're not going to catch current evictions. They're not going to catch current criminal stuff. So ask those questions when you're checking, and look for somebody that meets your needs. You need to make sure that it's going to that they're going to do what you want them to do. There's tons of different ones out there. Most of them are very good, but ask a lot of questions.
Okay, what was the name of the company?
Investigative Screening.
Screening. Okay.
So they go by ISC. It's Investigative Screening Corp.
All right. Okay, I'm going to send that out to everybody. Great.
Yep.
And these guidelines, the HUD guidelines, they're not Arizona specific, are they?
No, they're not. It's federal. So the guidelines are federal. Arizona has very few Arizona-specific guidelines. I mentioned a few cities. Tempe, for a while, had an ordinance where they wouldn't rent to 3 unrelated or more than 3 unrelated family members around the college, kind of doing some weird stuff there. I know Sedona and in that area, some of the resort areas have some specific to cities for that. But for the most part, Arizona mirrors federal guidelines, and these guidelines are federal.
Excellent. A couple questions regarding adverse actions. How should this notice be delivered? Certified mail, regular mail, email?
So it depends on how you got the application. What you want to make sure you have covered is that you prove you sent it. That's the big issue there. If you send it via email and you get a response, you're okay with that. During an audit, if they come in and they say, we want to see and prove that you sent these, don't just print it, put it in an envelope, and send it off. That's not going to cover you. You need to make sure you have a copy and a copy of how you sent it and that. That's really a question for the attorneys rather than me. I know we use email if we get a reply requested. It's one of the questions we ask when we ask on our application is an email address, so we send it via that. But you want to make sure you're audit compliant, and that's an attorney question. Lots of people just print it and mail it, and then when you get audited, they come in and say, okay, prove to me that you sent these. It's very difficult to do if you don't at least have a copy of it.
And what about applicants that don't have a Social Security number but have employment and a good rental history?
So that's going to depend on your policy. Depending on your policy, if they don't have a Social Security number, one of two things: either they have it and they're lying to you because they don't want you to pull it, or they're not here legally. Because if they're here legally on a work visa, they are issued a federal ID number, green card. We've heard that word before. They're issued a card that says for work purposes only. Again, talk to your screening company about what to do with that. They should have an ID number. So if they're working without any Social Security number at all, you have a good chance that they might get deported if they're not here legally. So the next question would be, prove to me that you're here legally. Again, policy. You want to make sure you treat everybody the same. If you require a Social Security number and they don't provide it, you're allowed to ask more questions. And I'm not just talking about Hispanics or Spanish descent. We have people here from Germany. We have people here at ASU that are teachers from all over the world. And it's the same thing. If they're here on a teacher visa or a work visa, they should be able to give you that information and say, yeah, I'm here legally. Because you would hate to rent to a teacher from Germany, let's say, that is allowed to be in this country for 3 more months on their visa, and you rent for 1 year in the house. Because 3 months from now, if they don't get renewed, they're leaving and there's nothing you can do about it. Are you doing your fiduciary responsibility to your owner if you rent to that person? So again, I'm not talking about just, we think about, Hispanics and illegal aliens and think about it. It's not just that. Almost all of the perpetrators of 9/11 were in Arizona in rental housing here illegally. Think about that for a second. So you need to make sure you have a policy, and if they don't have a social, stick to your policy. If your policy says you have to prove you're here legally, do it. If it doesn't, then treat everybody the same. So.
Excellent. Wow. So this one is kind of a interesting question. Say you have an applicant who sends in an application and you initially deny it for whatever reason. But then you go back and you look through the issues and you end up renting to them. Because you initially denied them, do you need to send them that adverse action notification?
Gosh, that's a tough one. I would say it probably depends on how much time went by. So if you call them and say, hey, you're denied, and they go, well, wait a second, I've got more information. Did you look at this? Did you do that? You're still negotiating, and you're probably okay not doing that. If they came back a few days later, I would say you probably should have sent it as soon as you denied it. You need to have a policy in place that sends that out pretty quick. And I don't think there's a guideline for a number of days. I really don't know the answer to that. I would have to look. I apologize. But I don't know if there's you have to send it within 2 days or 5 days or 10 days. I believe it says you have to send it within a reasonable amount of time. So if you deny somebody and you're still talking to them 2 weeks later, I don't know if that's a reasonable amount of time.
Excellent. I love this question that was asked. And are there any guidelines or anything about, let's see, a healthcare provider being related to the person that is requiring the assistive animal?
Boy, that's a tough one. I don't know if there is any specific federal guideline regarding that. That is a very interesting question, and one that I would say talk to your attorney about. I understand we do that all the time when we have rental history. Our criteria actually says you have to have X amount of years of rental history from a non-family member. So we covered that in our rental history, so mom couldn't say, oh yeah, Timmy rented from me, he paid his rent on time all the time. We know that's not valid rental history, so we kind of covered that on the rental history side, but I don't know if there's any guidance on the other side for a bona fide healthcare provider. I don't know. That's an interesting one.
Yeah, that's quite a question.
And there are so many of these guys where it's a case-by-case basis, and that's the whole point of this presentation and in talking about this. Starting the conversation. Don't just saying felony, no. No social security number, no. You have an animal, no, right? Those are all the things that get us in trouble when we're not willing to bend a little bit and to think about these things. I'm an old timer, and we were told you got to treat everybody the same. If you don't take pets, you don't take pets. That's it, blah, 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 and you got to toe the hard line. Well, it's coming around and getting a little different now. We're in interesting times. So talk to them, ask the questions, have the conversation, at least start that. If you deny someone for criminal background and they want to give you more information, be open to that. Have the conversation. That's okay.
That makes sense. Now, I know that on aaronline.com that we have some of our forms with a Spanish translation. Mm-hmm. So let's talk about, are there any regulations or anything that states that you need to have something in somebody's native language? What if no one in your office speaks that language? Do you need to hire an interpreter? How far does this go?
So in the state of Arizona, there's no requirement for that. There are other states, again, we talk about California, where you are required to provide that. Two things I've heard on that in talking with attorneys: if you do provide some forms in a foreign language, you probably need to provide all forms in a foreign language. You need to be very careful when you do that. If you provide the form in a foreign language and there's some error, some translation error, you're going to be on the hook for that since you provided it. So as far as I know, in the state of Arizona, there isn't any requirement for that. It's okay to say, I'm sorry, I don't have anybody here who speaks Tongan right now. You'll have to get an interpreter and come back. That's okay. You're allowed to do that. just make sure that they have an avenue for communicating with you and go from there. I think we have not provided any forms in Spanish. It's a business decision, though, and that's up to you as far as what you want to do for your business. And I say that probably depends on where you rent, what area you rent in. Do you have a big population that speaks a different language? If you do, you may want to think about it.
So let's talk about, is that discriminatory, not offering that? And what if maybe there's somebody who's a minor? How would you feel about having them interpret?
So it's not discriminatory as long as you're consistent. If you translate for some and not for others, that's discriminatory. That's where you're going to have an issue. If you're a small office with 3 people and you don't have anybody who speaks any foreign language, Spanish in particular, that's okay. You're not required to hire someone who speaks Spanish in order to do that. As far as having a child interpret, that's something that's a touchy subject. We see that with delivering notices, whether they're the age of consent. If you deliver a notice to the property to a 10-year-old, is that going to fly in court? Probably not. A 14-year-old, maybe. An 18-year-old, probably. An 18-year-old with a disability, probably not. So it's difficult. And if they have a person they're translating and it's a 7-year-old, I don't know if they understand the legal terms and are even going to know the words to do that, but you're going to have to pay attention to that to see. If they bring an interpreter, that's their interpreter. That's their responsibility to provide that and do that. They're the ones signing a legal contract and document.
Excellent. I think that pretty much answers that question. It's kind of like when you go home and you ask your kiddo, hey, did your report card come?
Right. Yeah.
It's kind of like, well, maybe.
I didn't see it.
Yeah. Well, Mike, thank you so very much. Any closing remarks today? Anything you want our audience members to walk away with? What's the one thing that they need to be aware of right now?
Just keep paying attention to this. It's going to change. We're going to get better guidance and clearer guidance on all of these things, but it's going to be a while. It's going to take a while for that to shake out in court. We've had other issues similar to this that have taken 7, 8, 10 years to come out in court. We had the federal guidance when they finally came out and said 2 per bedroom is a reasonable guideline to use and a reasonable occupancy standard to do. That took years and years for HUD to come around and give that out to us. So I hate to be the bearer of bad news, and it's probably going to take a while for us to get more specific guidance on this. And my whole point is you don't want to be the test case. So adjust your stuff now. The whole goal for any kind of audit, any kind of compliance issue is nothing to see here, move along.
And Mike, I know you're my compliance guy. You help people get their records together. Do you help with policies and procedures too? So if people had questions about those red flag things?
I haven't done that part of it. I have done that in the past. I've got limited time to do that now. So being the Southwest RVP and teaching for the state of Arizona and teaching for Colorado, Nevada, and Utah, and teaching for NARPM nationally, and that I've been pretty busy. So, but there are other people out there who do that. If you have a question, you can shoot me an email. I know some other people who do and can help you with that. And don't reinvent the wheel. There are lots of companies out there who have templates for red flags, rules, and policies and procedures just right out of the box. In fact, AAR has that, or the ADRE has that, where they have a broker policy menu right out of the box. Guys, go look at that. If you've been in business for 20 years, if you printed that off 20 years ago and haven't looked at it since, I guarantee you it's not valid anymore. Take a look at that. Change it. Update it. Need to do it.
Sounds like this is a great opportunity to be very proactive.
Absolutely. Absolutely. And when they walk in the door with the badges and the briefcases, it's too late. So do it now. We've had that at our company, and it's not fun. Yeah, do it now before they get there. Make sure you get in compliance.
I think bringing awareness to the 3 locks rule is so important. And people are like, oh, I've never heard that. No, it's nothing new, but it's definitely something that we need to be aware of.
Right, it's not. And when you think about it, people think, well, I'm property management. I don't do that. Well, actually, we're kind of issuers of credit. Don't we sign a lease for $1,000 a month for $12,000 and we set up a payment plan where they pay rent on the first of every month for the next 12 months? So you have to kind of think about those things and think about that. And just think about the sensitive information we have. Forget everything else. Think about the amount of stuff that you have in your office. Think about you taking those files and putting them in your briefcase and putting them in the trunk of your car. And you're in a car accident and the briefcase pops open and the papers fly everywhere. Do you know what was there? Do you know whose papers you had? Are you sure? If not, you got to tell everybody, I lost some stuff. That's scary.
Oh, that's a really good point, Mike. Thank you. And a great way to end today's webinar. Folks, thank you so very much for joining us today. I think everyone is saying thank you, and great information, a lot of depth, which our members truly appreciate. Thank you very much.
Well, you're welcome. I'm glad to help.
Again, thank you very much for joining us, everyone, and we hope you have a great week.